Number 51 of 1977. We managed to reduce it to writing, my lord, and we are ready to proceed. For the record also, my lord, the parties that signed this agreement is the DPP of Johannesburg, obviously the counsel of the accused person, my lord, the family of the deceased, and the investigating officer, Captain Mpeto, who is present here.
Thank you. Yeah, okay, this court has found it prudent to place on record the requirements of Section 105A, which relates to plea and sentence agreements. Section 105A, 1A, provides as follows. A prosecutor authorized thereto in writing by the National Director of Public Prosecutions and an accused who is legally represented may, before the accused pleads to the charge brought against him or her, negotiate and enter into an agreement in respect of 1. A plea of guilty by the accused to the offense charged, or an offense of which he or she may be convicted on the charge. And 2, if the accused is convicted of the offense to which he or she has agreed to plead guilty, 8A, a just sentence to be imposed by the court. B, the postponement of the passing of sentence in terms of Section 297(1)A or CC, a just sentence to be imposed by the court of which the operation or the whole thereof or part thereof is to be suspended in terms of Section 297(1)B. And DD, if applicable, an award for compensation as contemplated in Section 300. And then Section 105AB states, the prosecutor may enter into agreement contemplated in paragraph A, 1, after consultation with the person charged with the investigation of the case, 2, with due regard to at least AA, the nature and circumstances relating to the offense, BB, the personal circumstances of the accused, CC, previous convictions of the accused, if any, DD, the interests of the community, and 3, after affording the complainant or his or her representative, where it is reasonable to do so, and in taking into account the nature and circumstances relating to the offense and the interests of the complainant, the opportunity to make representations to the prosecutor regarding AA, the content of the agreement, and BB, the inclusion of the agreement of a condition relating to the compensation or the rendering of the complainant of some specific benefit or service in lieu of the compensation for damages or pecuniary loss. C, the requirements of paragraph B1 may be dispensed with if the prosecutor is satisfied that the consultation that the person charged with the investigation of the case will delay the proceedings to such an extent that it could, 1, cause substantial prejudice to the prosecution, the accused, the complainant, or his or her legal representative. 2, after the administration of justice, or affect the administration of justice adversely, Section 105A2, an agreement contemplated in Section 1 shall be in writing and shall at least A, state that the accused, before entering into the agreement, has been informed that he or she has the right, 1, to be presumed innocent until proven beyond reasonable doubt, 2, to remain silent and not to testify during the proceedings, and 3, not to be compelled to give self-incriminating evidence. B, state fully the terms of the agreement, the substantial facts of the matter, all other facts relevant to the sentencing agreement, and any admissions made by the accused. C, be signed by the prosecutor, the accused, and his or her legal representative. And D, if the accused has negotiated with the prosecutor through an interpreter, contain a certificate by the interpreter to the effect that he or she interpreted accurately during the negotiations and in respect of the contents of the agreement. 105A3, the court shall not participate in the negotiations contemplated in section 1. 4A, the prosecutor shall, before the accused is required to plead, inform the court that an agreement contemplated in subsection 1 has been entered into, and the court shall then, 1, require the accused to confirm that such an agreement has been entered into, and 2, satisfy itself that the requirements of subsection 1B, 1 and 3 have been complied with. B, if the court is not satisfied that the agreement complies with the requirements of section 1, subsection B, subsection A, subsection 3, the court shall, 1, inform the prosecutor and the accused for the reasons for non-compliance, and 2, afford the prosecutor and the accused the opportunity to comply with the requirements concerned. 5, 105A5, if the court is satisfied with the agreement that it complies with the requirements of section 1, B, 2, and 3, the court shall require the accused to plead to the charge and order that the contents of the agreement be disclosed. In other words, I can't hear the contents of the agreement entered into by the state and the defense and the accused until these prerequisites have been complied with.
That's what is.
So,
It has been so noted.
and the accused counsel,
I confirm that, Madam.
okay? Okay, so you can proceed thereafter then.
Before I proceed, my lord,
Okay,
per agreement with, there's a minor amendment, my lord, which the state now formally applies to amend count 1, my lord. It's indicated 2019, my lord. There in count 1, in fact, may be substituted with, may the 2019 be substituted with 2020. So it will read for June 2020, my lord.
is that the agreement?
Per agreement, my lord, the defense also has no objection with regard to this application regarding the proposed amendment to the year, my lord,
Okay,
as set out in the indictment.
so okay, in terms of section 88 of the Criminal Procedure Act, such amendment is granted.
As a court pleases, my lord. My lord, may I then now formally put the charges to the accused person, my lord?
Yes.
As a court pleases. Count 1, that the accused person is guilty of murder. That in that upon about the 4th of June 2020 and at a near Durban Deep in the district of Johannesburg West, the accused did unlawfully intentionally kill Tshego, a female person. Count 2, that the accused person is guilty of defeating the administration of justice. That in that upon about the same date and at a near the same place mentioned in count 1, the accused did unlawfully and with intent to defeat or obstruct the cause of justice, clean the car used in the murder of Tshego, which defeated or obstructed the administration of justice. Count 3 rather, that the accused is guilty of the contravention of section 3 of the Firearms Control Act, number 60 of 2000, that in that upon about the same date and at or near the same place mentioned in count 1, the accused unlawfully had in his possession a firearm without holding a license, permit, or authorization issued in terms of the act to possess such firearm. Count 4, that the accused person is guilty of the contravention of section 90 rather, my lord, of the Firearms Control Act, Act 60 of year 2000, that in that upon or about the same date and at or near the same place mentioned in count 1, the accused did unlawfully had in his possession an unknown number of ammunition without being a holder of A license in respect of a firearm capable of discharging that ammunition, B, a permit to possess the ammunition, C, a dealer's license, manufacturer's license, gunsmith's license, import or transit or transporter's permit issued in terms of the Act or otherwise authorized to do so. As a court pleases me.
Where's the interpreter? Your client, does he understand English?
He understands English, no.
Okay, section 6. A. That is section 105A, subsection 6A. Speaks about after the contents of the agreement have been disclosed, the court shall question the accused as to whether she or he confirms the terms of agreement and the admissions made by him or her in the agreement. With reference to the alleged facts of the case, he or she admits the allegations in the charge to which he or she has agreed to plead guilty, and the agreement was entered into freely and voluntarily in his or her sound and sober senses and without having been unduly influenced. B. After an inquiry has been conducted in terms of paragraph A, the court shall, if the court is not satisfied that the accused is guilty of the offence in respect of which the agreement has been entered into, or 2, it appears to the court that the accused does not admit an allegation in the charge, or that the accused has incorrectly admitted any such allegation, or that the accused has a valid defense to the charge, or 3, any other reason that the court is of the opinion that the plea of guilty by the accused should not stand, record a plea of not guilty and inform the prosecutor and the accused of the reasons thereof. If the court has recorded a plea of not guilty, the trial shall start de novo before another presiding officer, provided that the accused may waive his or her right to be tried by another officer. So what do you do after this? You disclose the contents of the agreement.
My Lord, I believe after the accused person has pleaded guilty, my learned friend will proceed in
Right.
reading.
Yes.
Only the part which is relating to the conviction.
Yes, of course, yes.
As a
What is your client's plea?
And it's guilty on all grounds.
That is the 3 charges. How many charges?
It's 4, man.
4, sorry, 4.
Murder, obstructing justice, firearm and ammunition.
Right.